Have you been screwed by Facebook or Twitter or, cough, YouTube? I know I have. For years, the tech giants have been harassing and censoring us, and they've always gotten away with it. Is that going to change with Trump's executive order on preventing online censorship? Let's take a closer look. Now, I find that whenever I mention President Donald Trump, two angry groups show up in the comments section. There are people who moan and wail if I'm not praising Trump, and there are people who moan and wail if I'm not condemning Trump. Let me say, in the name of full disclosure, that I regard the Trump can do no wrong camp and the Trump can do no right camp as equally moronic. The decisions of leaders need to be evaluated on a case-by-case basis. So, what should we make of Executive Order 13925? We'll start by considering the problem this executive order is meant to address. Way back in the 1990s, before some of you were born, internet companies like Prodigy and CompuServe, which some of you have never heard of, were facing some challenges. Are internet service providers responsible for the content posted in their forums and chat rooms? If someone who uses CompuServe posts a maliciously false claim about another person, can CompuServe be sued because it's hosting the maliciously false content? Notice, if the US government says, yes, internet service providers are responsible for the content posted in forums and chat rooms, there aren't going to be any forums and chat rooms, because any company with a forum or chat room would be sued into oblivion. The US government wanted to help these companies grow. So the Communications Decency Act of 1996 included Section 230C1, which declares, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." In other words, if you post something on CompuServe, CompuServe isn't treated as the publisher or speaker and therefore can't be sued for what you say. This is the basis for the platform versus publisher distinction. If a writer for the New York Times lies about someone and it's published by the New York Times can be sued because the New York Times is considered a publisher. There's an editorial board that decides what content goes into the paper and on the website. So the New York Times can be held responsible for defamatory content. But if someone posts defamatory content on Facebook, Facebook can't be sued because Facebook isn't considered a publisher. It's considered a platform. Facebook supposedly doesn't decide what people post. Facebook doesn't edit people's content. Facebook therefore isn't responsible for the content it hosts. There are exceptions, by the way. If someone posts content that's protected by copyright and Facebook is notified, Facebook is responsible for removing the content. There are exceptions like that. So the US government gave protections to companies that would serve as platforms for other people to post their content. But there was another concern. What if a company decides to remove or edit the content of one of its users? Suppose a man in a Prodigy chat room is having an online conversation with some kids. Suppose the man is clearly a pervert but hasn't broken any laws. Can Prodigy stop that conversation? If Prodigy can delete content, isn't the company a publisher rather than a platform? And if the company is a publisher rather than a platform, don't the protections of Section 230C1 go away? It seems that platforms need some sort of ability to edit or remove content without thereby losing their status as platforms. So the US government included Section 230C2. No provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. In other words, if Prodigy kicks some pervert off the platform because he's clearly a little too interested in kids, Prodigy is protected from liability. The company doesn't suddenly become a publisher rather than a platform because the company acted in good faith. So, the US government provided two important protections to online platforms. One, the platforms, with certain exceptions, aren't responsible for what their users post. And two, the platforms can restrict content in good faith. Sounds reasonable, right? Well, fast forward 24 years, and we have tech tyrants using the protections provided by the U.S. government in Section 230C of the Communications Decency Act to control people's speech in unparalleled fashion. The Orwellian trust and safety teams of Facebook, Twitter, and YouTube can censor any speech they don't like and hide behind Section 230C, claiming that they're only censoring content in good faith. Notice, if they're not really acting in good faith, they're not protected by Section 230, and by censoring content, they would be exposed as publishers rather than platforms, and they would be sued into oblivion. But are they censoring content in good faith? Of course not. The last video I had banned by YouTube was a video about the persecution of Christians in various parts of the world. YouTube labeled the video hate speech, gave my channel a strike, and blocked me for 7 days. So YouTube can silence me for reporting statistics about persecution. Is that what lawmakers intended when they provided the protections in Section 230C? Certainly not. But what can we do about it? Enter Trump's executive order on preventing online censorship. Now that we know the background, we can understand the executive order pretty easily. Let's read a few select paragraphs. Section 1. Policy. Free speech is the bedrock of American democracy. Our founding fathers protected this sacred right with the First Amendment to the Constitution. The freedom to express and debate ideas is the foundation for all of our rights as a free people. In a country that has long cherished the freedom of expression, we cannot allow a limited number of online platforms to handpick the speech that Americans may access and convey on the internet. This practice is fundamentally un-American and anti-democratic. When large, powerful social media companies censor opinions with which they disagree, they exercise a dangerous power. They cease functioning as passive bulletin boards and ought to be viewed and treated as content creators. The growth of online platforms in recent years raises important questions about applying the ideals of the First Amendment to modern communications technology. Today, many Americans follow the news, stay in touch with friends and family, and share their views on current events through social media and other online platforms. As a result, these platforms function in many ways as a 21st century equivalent of the public square. Twitter, Facebook, Instagram, and YouTube wield immense, if not unprecedented, power to shape the interpretation of public events, to censor, delete, or disappear information, and to control what people see or do not see. Online platforms are engaging in selective censorship that is harming our national discourse. Tens of thousands of Americans have reported, among other troubling behaviors, online platforms flagging content as inappropriate even though it does not violate any stated terms of service, making unannounced and unexplained changes to company policies that have the effect of disfavoring certain viewpoints, and deleting content and entire accounts with no warning, no rationale, and no recourse. Section 2. Protections against online censorship. A. It is the policy of the United States to foster clear ground rules promoting free and open debate on the Internet. Prominent among the ground rules governing that debate is the immunity from liability created by Section 230C of the Communications Decency Act. It is the policy of the United States that the scope of that immunity should be clarified. The immunity should not extend beyond its text and purpose to provide protection for those who purport to provide users a forum for free and open speech, but in reality use their power over a vital means of communication to engage in deceptive or pretextual actions, stifling free and open debate by censoring certain viewpoints. Section 230C was designed to address early court decisions holding that if an online platform restricted access to some content posted by others, it would thereby become a publisher of all the content posted on its site for purposes of torts such as defamation. As the title of Section 230C makes clear, the provision provides limited liability protection to a provider of an interactive computer service, such as an online platform, that engages in Good Samaritan blocking of harmful content. In particular, the Congress sought to provide protections for online platforms that attempted to protect minors from harmful content and intended to ensure that such providers would not be discouraged from taking down harmful material. The provision was also intended to further the express vision of the Congress that the Internet is a forum for true diversity of political discourse. The limited protections provided by the statute should be construed with these purposes in mind. In particular, subparagraph C2 expressly addresses protections from civil liability and specifies that an interactive computer service provider may not be made liable on account of its decision in good faith to restrict access to content that it considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. It is the policy of the United States to ensure that, to the maximum extent permissible under the law, this provision is not distorted to provide liability protection for online platforms that, far from acting in good faith to remove objectionable content, instead engage in deceptive or pretextual actions, often contrary to their stated terms of service, to stifle viewpoints with which they disagree. Section 230 was not intended to allow a handful of companies to grow into titans controlling vital avenues for our national discourse under the guise of promoting open forums for debate, and then to provide those behemoths blanket immunity when they use their power to censor content and silence viewpoints that they dislike. When an interactive computer service provider removes or restricts access to content and its actions do not meet the criteria of subparagraph C2A, it is engaged in editorial conduct. It is the policy of the United States that such a provider should properly lose the limited liability shield of subparagraph C2A and be exposed to liability like any traditional editor and publisher that is not an online provider. B. To advance the policy described in subsection A of this section, all executive departments and agencies should ensure that their application of Section 230C properly reflects the narrow purpose of the section and take all appropriate actions in this regard. So, this executive order, in effect, says that Section 230C of the Communications Decency Act had a purpose, and that the purpose was not to give a handful of tech companies control over what billions of people can and cannot say. The Good Faith Clause, or Good Samaritan Clause, was meant to protect internet service providers when they had to block certain dangerous or harmful content. It wasn't meant to give them blanket immunity when they censored content that they didn't happen to like. If this executive order is successful, these companies will have to make a choice. Either they can block content in the limited fashion that's explicitly laid out in Section 230C, or they can lose the protections provided by Section 230C, in which case the companies will soon be gone. Now, will this executive order be able to accomplish all of this? I do not know. I don't know if this is something that the president can enforce. I don't know if this is something that should be dealt with in Congress or the courts. I do know that there is a massive problem here. Online censorship is increasing, and it's growing more unfair and biased by the day. It needs to be fixed, and I don't particularly care who fixes it. I don't care if it's Trump or Biden or Obama or Hillary or Bernie or George W. or AOC or Congress or the courts. Someone needs to stop these companies from censoring people in bad faith while wearing a mask of good faith. This is bigger than Republican versus Democrat. This is foundational to our future. Over the next 2 months, we'll get a better idea of what impact this executive order will have. That's the time frame for some of the changes to be implemented. I hope that the problem is solved quickly. I doubt that it will be. But either way, I'll be following this story closely and I'll keep you informed.